Hello everyone, welcome back to Legal Study YouTube channel. Today we are breaking down chapter 17 of the Negotiable Instruments Act 1881. This chapter includes section 138 to 147, which was specifically inserted to bolster the credibility of checks in commercial dealings. It transformed what was once a simple civil breach into a criminal offense to ensure that promises on paper carry real legal weight. Let's walk through the statutory journey from the moment a check bounces to the final judgment. Section 138 of the Negotiable Instruments Act 1881 is a unique provision in Indian law because it turns a civil breach of contract, failing to pay a debt, into a criminal offense. For law students and practitioners, understanding of Section 138 requires its breaking down into its ingredients, the procedural timeline, and the punishment. Section 138 creates criminal liability when a check issued for payment of a legally enforceable debt or liability is dishonored due to either insufficient fund or exceeds arrangement with the bank. The provision was introduced to enhance the credibility of checks in commercial transactions. The essential ingredients of Section 138 are as follows. First, the check must be drawn by a person on an account maintained by him. Second, the check must have been issued to discharge a legally valid debt or liability. If a check is given as a gift or for an unlawful purpose, Section 138 does not apply. Third, the check must be presented to the bank within 3 months from the date on it or within the validity period of the check. Fourth, the bank must return the check unpaid, specifically due to insufficient funds in the account or it exceeds the arrangement made with the bank. Example, a credit limit. Fifth, once the check return memo is received, the payee must send a written legal notice to the drawer within 30 days demanding payment. Sixth, the offense is only committed if the drawer fails to make payment within 15 days of receiving the notice. Punishment under Section 138. If the ingredients are proven and the accused fails to rebut the presumption, the court can award imprisonment up to 2 years or fine up to twice the amount of check or both in some cases. Moving further, Section 139 deals with presumption in favor of holder. It creates a rebuttable presumption that holder received the check for discharge of a debt or liability. This shifts the burden of proof on the accused to prove that no such debt existed. Under Section 140, the law is even stricter. An accused cannot use the defense that they had no reason to believe that the check would be dishonored. In short, ignorance or good faith is not a valid shield here. Section 141 deals with the offences by the companies. Section 141 deals with the vicarious liability. It states that if a company commits an offence, not only the company but every person who is in charge of and responsible for the conduct of the business at that time shall be deemed guilty. The person liable may be directors, managers, secretary of the company. The only escape is proving the offence was committed without their knowledge or that they had exercised due diligence. Next up is Section 142, which deals with cognizance of offences. Section 142 lays down conditions for filing a complaint under Section 138. First, the complaint must be in writing. It must be filed by the payee or the holder in due course. It must be filed within 1 month from the date the 15-day notice period expired. Most importantly, these offences are non cognizable and bailable. Finally, let's take a look at how these cases move through the court. To prevent these cases from clogging the courts, Section 143 empowers magistrate to conduct summary trial with an endeavour to conclude these cases within 6 months. A vital tool for complainants in Section 143A was introduced to provide immediate relief. The court can order the drawer to pay interim compensation up to 20% of the check amount while the trial is still pending. This ensures that the complainant isn't left empty handed during the long legal battle. Section 144 and Section 145 allows for the service of summons via speed post and permits evidence to be given via affidavit, significantly speeding up the testimony process. Section 146 states that the bank slips or memo is treated as a prima facie evidence of dishonor. You don't need to call a bank official to prove that the check was bounced unless the memo is specifically challenged. Section 147 states that these offences are compoundable. This means the parties can settle at any stage, even after a conviction, reflecting the Act's ultimate goal of recovery over mere punishment. That's a wrap on Chapter 17. It is a perfect blend of criminal procedure and commercial law. If you found this breakdown helpful, hit that subscribe button and let me know in the comments which case law would you like me to deep dive into next. Happy studying!